Well, hello everyone, and welcome to the Global Mangrove Alliance webinar on mangrove restoration, law and land tenure. I'm Dr. Chris Brown, co-leader of the Mangrove Alliance's Science Working Group. Now in Australia, before we give presentations, it's traditional to acknowledge the Indigenous people of the lands on which we work. So I'd like to acknowledge the Indigenous people of where I'm working, the Palawa people. And then more broadly across the mangrove community across the world, I'd just like to acknowledge the value that cultural science plays in the conservation and restoration of mangroves. So today we're going to be looking at the tricky issue of law and land tenure and how that affects mangrove restoration activities. And we have three experts to present to you today. So we'll hear from them with some short presentations, and then at the end we'll have time for a question and answer. So first up we'll have Associate Professor Justine Bell-James. She's an expert in environmental law and has published extensively on legal impediments and coastal restoration, and also on issues around sea level rise and the law. Then we'll have West and Mardha Tillah, both from Landesa. That's an organisation that works with communities on land rights, and they're going to focus on talking about Landesa's work in Southeast Asia, and particularly Indonesia. Just for those of you that are new to Zoom, if a question comes up for you during the webinar, there's a Q&A button down the bottom. So you can click that and type your question in, and we'll answer the questions at the end, or feel free to use the chat feature as well. And if people would like to talk up with their questions, if you let me know via the chat, and I can allow you to talk at the end. But without further ado, I'll hand over to Dr. Justine Bell-James.
Cool. Thanks, Chris. And thank you very much for having me today. All right, you can see my slides okay now?
Yep.
Excellent, thank you. So I'm just going to give you a short talk today on my perspective from Australia and the legal and land tenure issues that we have grappled with and are continuing to grapple with in both protection and restoration. And like Chris, I too would like to acknowledge the traditional owners of the country from which I am joining you today. So I'm in Mianjin, Brisbane, which is Yagara and Turrbal land. So in Australia, like a lot of countries, we have a pretty extensive legacy of mangrove loss from a variety of drivers, including development. We have a really strong history of clearing mangroves to improve ocean views, and also a lot of clearings happen in the past due to agriculture, and I'm going to come back to that shortly. So to deal with this legacy of loss, and I guess to try and stop further loss from occurring, over time we've developed a lot of legislation and policy in Australia to try and protect mangroves and prevent further clearing from occurring. So this is from a paper that I did a few years ago now, where we went through and mapped the legislative protections that we have for mangroves in Australia. So we've got some at the federal level up in the top left-hand corner there, and then we've got legislation and policy that exists at every state in Australia as well. So the blue boxes are legislation, and the green boxes are things that are non-statutory policy. So it's a pretty complex and confusing mosaic of protections that we've got. Most of these are your classic sort of command and control regulations. So a prohibition on clearing unless you get a permit or an approval to do so. So it's not absolute protection in most cases, but you need to go through that process of getting a permit. If you fail to do that, then you might be subject to compliance and enforcement mechanisms. So this is quite a recent case that hit the news earlier this year, where somebody in North Queensland had cleared mangroves to be able to access the water from his property, and received a fine for doing so. So sounds pretty nice in theory, but of course, if you engage with that process, there's probably a good chance you end up getting a permit in the end, statistics would tell us. We also do have a lot of mangroves in protected areas in Australia, and they receive a higher form of protection. But outside of those protected areas, then you're just looking at those sort of permitting pathways. Now, coming back to agriculture, which I mentioned before, we have a pretty extensive history in Australia of conversion of saline wetlands to agriculture. And this has largely been through the use of what we call ponded pastures. And here's a little diagram here from a paper I published with Kath Lovelock about 5 years ago now. So farmers would build these bund walls or these pondage banks either across a stream or sort of on a slope on their property. And the idea would be that it would catch fresh water during the wet season. And then as the land would dry out in the dry season, they'd be left with nice green grass so that they could graze cattle year round on their properties. So really increased agricultural productivity, but the removal of tidal influence led to a pretty significant decline in the coverage of coastal saline wetlands. On the flip side, if we go and use heavy machinery, like in the picture on the right here, and remove these bund walls, then that saline hydrology can be restored and saline wetland can be re-established. And so there's been a lot of work done in this area in Australia over the past 10 years or so in terms of modelling how the wetlands will re-establish and importantly, what the likely carbon abatement will be from that. And this is because the carbon market in Australia has become a pretty big driver of a lot of restoration that happens. So in Australia, we have what's called the Emissions Reduction Fund, which is our overarching carbon market legislation, which really puts in place a framework to reward particular types of carbon abatement activities. So to engage with the ERF, you have to have what's called a methodology determination that covers your activity and basically sets out what you need to do to be able to get carbon credits and how you calculate carbon abatement generated. So prior to 2022, we didn't have any methodologies that applied to mangroves or wetlands more broadly. But myself and a lot of others in the science community worked fairly extensively with our federal government over a number of years, and the blue carbon method became law in 2022. So it allows for this activity, going back to here, that removal of tidal barriers to be credited with Australian carbon credit units once you can calculate that carbon abatement has occurred. So that's been a real driver of restoration over the past few years. But land tenure makes it really complex. So I guess in Australia, like everywhere, coastal ecosystems like mangroves occupy the intertidal zone, which is a really complex space from a legal perspective. So it's right, certainly in Australia and in a lot of countries as well, it's the place in the landscape where different tenures intersect. So in Australia, we have what are called ambulatory boundaries in tidal areas. They move in and out with the tides, and where exactly this boundary is depends from state to state, and that's what you can see in this diagram here. So in some states, it's the mean high water springs, in others, it's the mean high water mark, and as that changes, the boundary moves in and out. So that can make it really complex to determine exactly where rights and ownership lies in that particular space. And it's also really complicated from a jurisdictional perspective because you might have different government agencies that have responsibility for effectively the wet and the dry part. So it means that doing restoration and doing carbon projects in this space involves a lot of uncertainty as to who has the rights to do what, and importantly, who'll have the rights to any carbon credits that come from doing that work, and also which government agencies you have to engage with to be able to get the permits to do that. And of course, resolving these questions is becoming much more urgent given this global shift towards restoration that we have occurring at the moment. So as we know, we're about halfway through the UN decade on ecosystem restoration now. And of course, we've got the commitment under the Global Biodiversity Framework to have at least 30% of degraded ecosystems under effective restoration by 2030. So a lot of work happening in Australia, like a lot of other places, to try and resolve some of these legal barriers to allow for the upscaling of restoration. But the really great irony is that we've established such a strong series of legislative protection for these sorts of ecosystems, such that it's now really difficult to restore them. So we don't have dedicated legislation in Australia to allow for restoration. There's no particular restoration permit that you go out and get. So if you want to do one of these reintroduction of tidal flow projects, so if you want to pull down a bund wall to let the tides come back, these are the permits that you might need to get just in Queensland. I'm not going to go through these in any detail, but you can see from our little traffic light diagram here, the red ones are ones you absolutely need. The orange ones are ones that you might need. You have to really assess the project you want to do, the land it's on, what's involved with the particular methods you want to use to see if a permit's needed. And then the green ones, you don't need a permit, but you need to comply with some sort of code. So there's been a lot of really really interesting work written about this and the protection-based paradigm that we have in Australia and a lot of other countries that's really acting as a massive impediment to be able to get restoration done because it's effectively treated like any other activity that's going to interfere with an ecosystem, such that you need to get those permits. So anyway, that's all I wanted to say about the legal barriers that we've got in Australia today. I'll hand over now to Mark and Tilla, and I'm really keen to answer questions at the end. So thank you.
Thanks, Justine. It was great. While Mark and Tilla set up their slides, I'll just remind everyone that last webinar we had one on carbon accounting in mangroves. So if you wanted more background on the blue carbon method and carbon accounting, I'll just post a link to that in the chat. Are you ready to share, Mark?
Yeah.
Thank you. Right, and just a reminder, there's a Q&A button down the bottom if questions come up for people during the talks. Over to you, Mark. Thank you.
Yeah, did that share work there, Chris?
Yep.
Okay. Well, thanks, Justine. Thanks, Chris. I'm Mark West. I work with Landesa, and I'm here with my colleague Tilla, and I'm the regional director for Southeast Asia, and Tilla is the country director for Indonesia. And we have sort of a branding mix because we have a local yayasan in Indonesia. You see it there. And then I'm going to shift over to Landesa Global in a second. But just a quick overview, as Chris said, we have been working for about 50 years now with communities and governments around the world to try to strengthen land rights for the poorest people. And in the coastal area, that involves a lot of fishing communities that live among mangrove areas. And it's a really important part of our work in Southeast Asia, and it's a kind of a different time there in Southeast Asia than what we listened to Justine talk about. Restoration is not really the big priority in our view. It's more protection, making sure that these communities have secure rights to their lands. We're talking about, hundreds of millions of people who are highly insecure. And so really it's about securing their tenure rights and protecting the mangroves, and then hopefully there'll be less restoration down the road. So quick overview, this is our area where we work. It's all the way from West Bengal on the left-hand side of the map there in Bangladesh, the Sundarbans, through Myanmar, through Thailand and Cambodia, and then all through Indonesia. So there's plenty more mangroves in the neighborhood, but these are the countries that we work in. We work with national level governments, provincial level governments, civil society organizations, and communities to take a look at the legal framework and try to improve policies and laws to strengthen coastal tenure rights so that these local communities can protect their livelihoods and the geographies where they live. So I'll give you a quick overview of Myanmar, Cambodia, and Thailand, since those are some countries where I've been working closely, and then Tilla will do the remainder with Indonesia. So just briefly, here's a few examples of what these laws and policies are. So in Myanmar, we take an approach which is community forestry. So there, you have different legal frameworks for upland forest communities, lowland farming areas like paddy farmers, and then coastal fishing communities. So in the mangroves in Myanmar, it's community forestry is the legal mechanism. For many years, there was a community forestry instruction that did not protect mangroves at all, wasn't even mentioned. So they were completely unprotected. The communities could not have tenure rights to the mangrove areas. And for those of you who know Southeast Asia, there was a lot of clear cutting going on, a lot of turning into charcoal, building all kinds of plantations, fish ponds, rubber trees, oil palm. Then in 2015, 16, 17, several groups, including Landesa, began to work with the new reform government, and the new community forest instruction was passed. And now mangroves are protected within community forestry, and hundreds of communities, tens of thousands of hectares are now under protection of community forestry. If you jump over to Cambodia, there's a different approach there. It's not community forestry, it's community fisheries. There are a bunch of legal mechanisms, but I'll just mention briefly there's a new national land law that's being drafted now. The new draft has mangroves in it as a result of advocacy by groups like Landesa. And then if you look at the nationally determined contributions, which Justine was just referring to a little bit ago, if we look at the global level, community fisheries to protect mangroves are being included in the NDCs. So that's a way to try to have global pressure to lock in these legal rights. And then Thailand also has a community forestry approach. They have a new Community Forestry Act 2019, also includes mangrove protection. However, there's a tough regulatory framework, and there's roughly 1,000 communities in southern Thailand in these coastal mangrove areas who do not yet have proper community forestry certification because there's a specific Department of Marine Coastal Resources, and they need to certify all these communities. So in Thailand, kind of the work there is more of an implementation hustle. So working with hundreds and hundreds of communities to get certified. So that's kind of an overview, and we can talk during the Q&A, and I'm going to keep on clicking, but I'm going to pass it over to Tillah, who's going to talk about Indonesia.
Okay, thanks, Mark. I'm going to make this quick. So yeah, in Indonesia, the World Bank data say that there are 420 million Indonesian people depend directly and indirectly on mangrove ecosystems. So we are thinking that while mangrove is actually approached mostly by management aspect, we're talking about tenure issues, and especially in areas that is not categorized as forest. Next, Mark. Next, please. Next slide. Yeah. So just some overview. In Indonesia, mangrove is categorized into categories. One is inside forest zone, which is about 2.6 million hectares, and outside forest zone areas, categories as other land use category. And we are now, at this moment, Landesa is working on outside forest zone mangroves, because the one inside forest zone, there are already mechanism called social forestry carried out by the Ministry of Environment and Forestry. Both of these mangrove areas are actually accessed, managed, and some of them are considered as ownership of some other communities or customary law communities, apart from also local communities or official folk communities. Next, Mark. Yeah, so going inside, even zoom in to this mangrove inside and outside forest zone. I'm talking about what Justine also mentioned. In coastal areas, there are many regimes. One is inside the forest zone areas. The Ministry of Environment and Forestry is handling responsible taking care of the mangroves, which is about 79% of the total mangrove in Indonesia. While outside the forest zone, there are two different ministries that are having some responsibilities or jurisdiction. Inside the coastline is defined by another agency called Geospatial Agency Body. Inside coastline, it is about, I mix up the number, it's supposed to be 20%, which is 672,000 hectares. That is under Ministry of Agrarian Affairs and Spatial Planning. And the other one, the rest, 1% of it is outside coastline, which is under the Ministry of Marine Affairs and Fisheries. And they have different regimes, different approach, and also different paradigms. Next, Mark. So talking about this situation of mangroves in Indonesia, the existing mangrove forest, as I mentioned before, there are 3.3 million, 700,000 of it is on non-forest area, and there are potential of mangrove habitats, which is the target of restoration, about 756, and most of the restoration needed is in the other land use or non-forest area. So the Ministry of Agri and Spatial Planning is now also thinking about how to approach to contribute to this environmental NDC, for example, through this restoration and thinking about now they're starting to think about how to approach to understand the environmental indicators, which is not their nature. Next, Mark. On this degraded area or areas that need to be restored, the situations are there are clear areas becoming plantations. There are abrasion areas, fish ponds, shrimp ponds, and some accretion land, which is also categorized as forest and then non-forest areas. I'm just giving some overviews of the situation. Next, Mark. So now there are 3 avenues of Indonesia government for mangrove protection. Recently, there are already some regulations, but the Ministry of Environment and Forestry is now trying to unify the mangrove ecosystem formal governance using a landscape approach. So they are approaching the mangrove management by defining which ones are under protected categories, which one are under what's called development categories, if you want to put it. And then there's also a draft of presidential regulation that Landesa is also supporting right now on rights recognition or determination on waters, coastal and marine areas led by the Ministry of Agrarian Affairs and Spatial Planning or National Land Agency. So what is interesting here, initially and naturally, the Ministry of Agrarian and Spatial Planning is thinking only about rights over housing above water, because they are thinking that the mangroves are actually more into environmental aspect, and there is the responsibilities of different ministries, such as the Ministry of Environment and Forestry, and also the Marine Affairs. But now mangrove is part of the norming, and also the Ministry of Marine Affairs and Fisheries is in the process of preparing a Minister of Marine Affairs and Fisheries regulation on OECMs. So as Justine also mentioned already, that now Indonesia is trying to reach 30% of conservation areas by 2045, not 2030. And Ministry of Marine Affairs and Fisheries is leading on this. And in subnational level, just going in our subnational work, the authority body of the new Nusantara capital city is preparing head of authority body regulation on coastal management, which is we consider one of the first combining management and tenure for the first time, which is not always the case. Next, Mark. So what we learned so far is, as I mentioned, that these 3 ministries have different paradigms. One is very familiar with tenure, but not familiar with environment aspects. And the other 2 is very technical on management, environmental management, but thinking that often think that tenure is seen as a threat or counterproductive to achieve conservation objectives, although the Ministry of Environment and Forestry has actually providing various mechanism on social forestry, but that is not really the nature. However, the biodiversity framework according Montreal has shown that actually their tenure and also environment protection can be hand in hand. So there's a new window, as I mentioned, that Marine Affairs is now preparing the OECM policy and practice. And the Ministry of Agrarian Affairs and Spatial Planning is in the process to set the new norming to be able to recognize communities tenure to mangrove areas, because before, they are not prepared with what if the community is not doing anything such like anything, because they're not planting, they're not tilling, they're not building anything in a place because they want it to be protected, and there is no norming prepared for that in the Ministry of Agrarian Spatial Planning paradigm. So this is now on process, and the exercising rights recognition or tenure security in protected zone is now also being under exercised, because before this is not the case. Like protected zone needs to be free from community tenures. Next. Yeah, just going just a bit about the our work in the new capital city. We see that in new capital city there are 54 coastal villages in the area, which is a home of 157,000 people, directly and indirectly dependent to mangrove ecosystem. So together with the authority body, we conduct 3 assessments to understand the mangrove and then tenure issues and the ecosystem services that they are providing. We are trying to understand what is the cultural values and then food provision and other aspects such as carbon sequestration in the area. So next, Mark. Yeah, this is just to show that we try to measure this carbon sequestration to have a language saying that if we keep one of the site, only one village within the Nusantara capital city of the mangrove covers for 20 years, it means that it can conserve, it can avoid carbon emission in 20 years, equal to 1,000 of 60 ordinary passenger vehicles. And next. Yeah, so we are learning that from the process in Nusantara capital city that land use change does change land tenure system. So the mangrove forest used to be under communal tenure system, but since it is converted into fish ponds, they are now under individual tenure system. And it could be also be the other way around as we are talking to the communities on the ground. So land tenure security and clear arrangement of land use, such as using the instrument of rights, restriction, responsibilities, incentive and disincentive will contribute to the new capital city vision to be forest city. This is the vision of the capital cities. That's why they're focusing first on this environmental related protection regulation. And then the food provision, which is targeted 10% of the area, should count areas managed by the communities by securing their tenure to these food production areas. We learned from the assessment that mangroves is actually source of food of the community. And while the new capital city authority is targeted to produce their own food, which is covering 10% of their area, they should, instead of thinking about clearing lands and building like monoculture plantation or anything, they should have also we recommend that they can also count these areas of mangrove ecosystems. And then we're thinking that to be able to be left no one behind in this coastal management, it needs to be linked with social welfare targets such as food provision, health and education. So it can be linked with, it can cover and then become inclusive to women's dominant domains like food provision, and then thinking about the younger generation. Next. Yeah, well, thank you.
Thank you, Tillah. Excellent. While people get ready for questions, I just have a question for you, Tillah. How's this forest zone defined? You talked about mangroves inside the forest zone and outside the forest zone. How's this forest zone defined, or where does that come from?
Yeah, so the forest zone is an area that is decided by the Ministry of Environment and Forestry as forest area, and it needs to be about 70% of total area of Indonesia. So sometimes there are areas that are not anymore covered by vegetations, but it is still categorized as forest. On the other hand, forest areas that is covered with vegetation, such as also mangrove, but that not included in this category is not categorized. It's not called forest, I mean, formally.
Oh, right, yeah. That has implications for the land tenure and how it's who's managing it and how it's managed.
Yeah.
Great, thank you. So I'll just remind people to use the Q&A if you have questions, or feel free to use the chat if you'd just rather speak your question. I'll ask another question of all the panelists while I've got a moment. If you comment on the effectiveness of legislation, so we talked a lot about like what legislation's in place and so forth, and what's your experience with how effective that legislation is? Maybe I'll go to Mark first, then Tillah, and then Justine.
Yeah, that's a great question, and it really depends on the country and the context, and the political will of that country. So we saw in Myanmar during the good times between 2015 and 2020, there was a lot of political will to try to conserve forests, upland and coastal, to try to get land rights into the hands of the communities who live there. So there was actually a lot of momentum to both amend the community forestry instruction and then roll it out to communities. So that roll it out part is really important because titling is labor intensive. If you're titling individual households, it's very labor intensive. If you're titling communities, not so much, because you can, title 1,000 hectares and 250 families with the stroke of one pen. It still requires a lot of planning. The community forestry process is not just super quick. You have to do an application. You have to have a community forest management committee, user groups. So I think that if the government really wants to do the work, and if communities are involved and civil society groups are involved, it can be a pretty brisk process. Landesa doesn't work in every country. We work in places where there really is political will and need. Indonesia, we kind of kept a distance for a long time, but really there has been a lot of momentum the last few years. I think we saw a lot of evidence of that with the former president with a peat drainage moratorium and then a new oil palm plantation moratorium. And these two were shown to dramatically reduce the rate of deforestation. There was a WRI study on that was really powerful. But those are just presidential orders that need to be followed up rather than being something in the negative, which is a moratorium against something. We're trying to push something in the positive where you're securing those communities' tenure rights that can outlast, a presidential order that can last, 30 years or forever. So.
Right, thank you. And I'll over to Tillah then. Do you have any comments on how effectively it's implemented the legislation? Yeah.
Yeah, I think one of the first is also the understanding of the community's understanding on the legal the provision that is there. We see on the ground often that there are already regulations and everything on mangroves, but then the community don't really understand what it is, and often that when they sort of cut down the mangroves, for example, they call it it's violating the regulation, but then they actually, because they have no idea. And then I think the other two is that what is still not strong in our governance system is the monitoring and evaluation, like the how to say it's succeeded or not, and when people need to be sanctioned or not, and also incentive. That's why I also mentioned that we really want to learn how to be effective in doing this incentive and disincentive. And I think also the post rights intervention, like after their tenure is secure, then many government intervention needs to be followed up. Yeah.
Right, thank you. So yeah, the land tenure is like really a first step to then helping communities have more rights to manage the land the way they see. And Justine?
Yeah, I guess it's a really different context here, but how effective our legislation is it's a pretty vexed question in Australia at the moment. So we have, if we look at the federal level, so we've got legislation at the federal level and then at the state levels that ostensibly protects ecosystems, including mangroves. If you look at our federal legislation in its 25-year history, there's statistics that show that 99% of projects that are assessed under the Act are ultimately approved. So even though we have these protections, in legislation, there are only protections without having the necessary approval. And the statistics show that more often than not, you will get an approval to do these things. And, the approval might come with conditions. It might come with measures in place ideally to try and limit the impacts on ecosystems. But yeah, we've got some really big glaring loopholes in our legislation. We've been in a process of law reform of our federal environmental law for the past couple of years, but certainly the last year it's really ramped up. And it looks like it's going to be a complete failure. It looks like we're not going to have any success in getting these laws to pass Parliament because it's just such a politically vexed issue in Australia. Putting in place robust protections that don't allow the ministerial decision maker that ability to override those protections. So if they're effective, I think it's really hard to say that. We've got a global nature positive summit underway in Australia at the moment where our government's really trying to show the world some great stuff happening. But I think the effectiveness of the legislation we have is really, it's really not very effective.
If you've got the resources to apply for the permit, which looks like a massive undertaking on its own, then you probably get the approval.
Yeah, that's right.
And
then on the other side, we've got the restoration practitioners that then have to engage with exactly the same permitting process, except often they don't have those resources. We're often talking about under-resourced NGOs that are trying to get public good works done, that also have to go through this complex permitting system and are finding it really challenging to navigate.
Have you ever ran into that, Mark and Tillah, like issues with laws that are meant to halt development, then holding up types of activities you want to do, or the synergies there?
Yeah, you can give a quick example and then Tillah maybe. So the community forestry instruction in Myanmar before, so back in the 90s, they had one. The idea in general was to let communities be foresters, log. The system was corrupt back then, and the communities were often used by other forces to do that. But to be more specific, the old instruction, it had a prohibition on what they called gardening, which basically means like small farming in your community forestry, in your community forest. And also a ban on shifting cultivation, so a traditional indigenous or ethnic rotational farming approach, which is actually good for carbon sequestration. So those are examples of counterproductive law that they're trying to push logging, basically. And they're saying, you can't farm on a little bit of your forest, and you can't do shifting cultivation because that's, too much of a indigenous land right, I guess. So those were in the change in 2019, those were eliminated, which was a wonderful thing. To have mangroves added was great, but also for the upland forests to have the gardening prohibition eliminated. So now you can have a small farm in your community forest, and then to have the shifting cultivation ban lifted so that people can practice this very important traditional Swidden agriculture.
That's probably more conservation orientated too, a bit more sustainable in the sense that you can do it with the forest still there. That's great. Thanks for that example, Mark. Tillah, did you have comments on that issue of laws or holding up protection or restoration?
Yeah, I think after a quite massive forest fire back in 2015, I guess, in Indonesia, there's this body established called Mangrove and Peatland Restoration Body. Since then, I think we don't have that much forest fire anymore, because there are plenty of intervention being done and then regulations applied, including on clearing. The way that people are clearing their land now is very regulated. But as Mark also mentioned, that there's also affected the indigenous communities who has traditional wisdom in doing this. And I think very recent social forestry also has been set as a priority since 2015 or 16, and there are massive social forestry permits being released for forest communities. And recently, there's Ulayat land or indigenous people's land recognition, just only this 2024 being released, enacted by the Ministry of Agrarian Affairs and Spatial Planning. And we are trying to exercise how this regulation can also protect mangrove for the indigenous communities that have mangrove as part of their traditional land.
Great, thank you. And that got me thinking about, Indigenous communities and their involvement with mangrove conservation. Justine, on one of your slides with the stoplights, you had a thing there about Indigenous cultural guidelines. Do you want to just fill us in a bit more about that, if you've got the expertise to talk about that?
Yeah, it's pretty complex in Australia. So we have a system of native title in Australia now, where effectively our High Court recognised, 30 odd years ago now that the Indigenous inhabitants of Australia have, traditional ownership rights over land, and they can go through a legal process to claim rights back. And that's either exclusive rights or non-exclusive native title, which means that those rights coexist with any other rights to land. So, it sort of differs all around Australia's coast. There are areas, particularly in northern parts of Australia and the Northern Territory, where there are pretty significant native title determinations over intertidal areas. And in those circumstances, it's actually probably easier to do restoration and to do these sorts of activities because those determinations will cover the entire intertidal area. So there is a lot of work at the moment going on around, developing new carbon methods for traditional owner groups to be able to do restoration in those places. So, for example, Kath Lovelock here at UQ is working on one for feral ungulate control in wetlands, so feral pigs effectively, and really working with traditional owners to make it an Indigenous-led method to create opportunities, as well as, I suppose, capitalise on that particular space where traditional owners really do have the rights to manage their land. In other places, it's a lot more complex. So a lot of other parts of the coast, there aren't native title rights. There are, either private or state ownership of land, but there'll still be sort of overarching entitlements for Indigenous groups to be consulted in relation to things that happen. So yeah, it kind of adds this other layer of complexity, and it really depends on where you are as to how robust the rights are to Indigenous groups. But yeah, it can either be something that that really helps things, like it does in northern parts of Australia, as I said, or it can be kind of an additional layer of regulation in those other areas.
Great, thank you. And actually, that sort of answered a question someone's put up, which was about the relationship between land tenure and carbon rights. So it sounds like in some of those cases, Indigenous land tenure actually spans all the different types of mangroves and makes the carbon capture and storage more feasible.
If I could just sorry, I was just going to say in Australia that has been a real sticking point, because particularly with that moving inland of coastal wetlands, it then raises these really complex questions about whether, when the wetlands move, they'll actually be on public or private land, and we can't really answer that. So
that's with sea level rise and
and then sea level rise complicates things as well. And I think there's still a live question as to what will happen with boundaries under sea level rise. So in Australia, we've been able to put just kind of a neat band-aid over it, actually, which is by having a system in place whereby the government and the private landholder can contractually agree to assign all the rights to the landholder. Excuse me. And the governments are quite happy with that, because at the moment they're quite keen to get these carbon abatement projects happening, even if that means giving a private landholder rights. So we've been able to band-aid over it, but if that weren't the case, it would be a really tricky question to resolve.
Great, thank you. Mark and Tillah, do you have any comments on this question? Actually, there's two related questions now. One's about the relationship between land tenure regulations and carbon rights, and then the other one was this more direct question. do communities have to acquire status before they can register rights to carbon sequestration?
I can start with that because we're doing a lot of work in Thailand in this area, and Tilla can talk about
Right.
she gave a little bit in her presentation about it, and there's a lot more to learn there. I just listening to Justine, it sounds so lovely, the band day that you're talking about, but assigning the rights to communities is not happening quickly when it comes to carbon credits and the benefits that flow from that. It's a very contested area. There's basically two big issues that we see. And first of all, to answer the question directly, yes, in Thailand, for example, and I think in many of these areas, you have to have tenure rights to the area in order to receive benefits from the carbon credit scheme. So it's a gateway issue. You got to get those tenure rights if you want to have a chance to get some kind of compensation, some kind of payment for ecosystem services. So assuming that you have that.
Thailand, you have.
Sorry?
In Thailand, there was a massive list of communities waiting to get on the list, right, to be registered. So
Yeah.
even that's just a huge impediment then.
Yeah, exactly. So let's just assume those 1,000 coastal communities get community forest certification with DMCR, which is the Department of Marine and Coastal Resources. So that's the gateway in. But then once you're in, then there's two big issues. First of all, do you really have a fair bargaining process? You know, the free, prior, and informed consent. You have to be able to negotiate and understand what these rights are, and understand what the benefits are, and understand what your role is. And so that FPIC, as we call it, free, prior, and informed consent, is a crucial part of this. Otherwise, very sophisticated, powerful actors are just going to roll over these communities. And then the second thing is the ratio of the benefits, because you know, I don't want to call out specific countries, but we were just talking about one, so it might be that country. The percentage of funds that go to the government and the percentage of funds that go to the broker is significantly more than what the community gets. The community gets a small minority of those funds. So I think there needs to be some reform there in the way the policy works, because this is the case for a lot of these countries, but as anybody who's involved in the blue carbon space knows that the amount of money that goes into these communities is tiny. And I'm not just saying that as a, you know, a radical at a podium. It's just facts. I mean, they're getting tiny amounts of money, and then the government gets more, and then the private companies that are the brokers get much, much more.
And then I guess that means they might have gone through this process to have recognized their tenure, but then they've signed this contract that means they can't do anything else with the land, and they're not getting any of the funds from all the benefits of that.
Yeah, I mean, our argument is that they should have tenure rights anyway. I mean, forget blue carbon, forget payment for ecosystem services. They should have secure rights to their traditional livelihoods and where they live, and where they've lived for hundreds and hundreds of years. From that position, then you can start negotiating and try to get other benefits.
Right, thank you. And Tilla, did you want to talk about the situation in Indonesia with tenure and carbon rights?
Yeah, I think yeah, that's really a big discussion here in Indonesia, especially for the customary law community or indigenous communities, thinking that this is another, it can be another eviction of these communities from their forest, from their source of livelihoods, just like previously it is a big plantation and then minings, and now this is could be another way of affecting them. I'm just going to say that that the carbon thing is actually the focus of the Ministry of Environment and Forestry, but then now the Agrarian and Spatial Planning is also thinking how they can also contribute to this carbon trading, because this is such a massive business right now here in Indonesia. But there's threats that in concession land, like land leased for some companies for plantation, if it's abandoned for several years, it is not taken care. It is an object of land redistribution to be redistributed to the landless farmers. But this carbon scheme might, in fact, it might be used as a reason for them to abandon the land for for this carbon sequestration reason, but then after 20 years, then they cut it down for another plantation because maybe they have money or anything. So there is some pitfalls in that too that the ministry needs to take account of.
Great, thank you. Oh, there's just one more comment. Just a comment on the topic from Fair Carbon. That's an organisation that works on carbon trading, I think. They've been analysing regulations on land tenure carbon rights of different countries, and it varies within countries. So they've published 11 country profiles. Oh, if you share the link to that in the chat, that would be great. I think, Mark, you also mentioned a World Resources Institute study earlier on. If you have the link handy, you could share that. That would be great. It was about the effectiveness of regulations, I think. I was going to follow up on that, Tillah, and just ask, you mentioned carbon loss abatement potential where the new capital was going in Indonesia. So people don't know Indonesia is developing a new national capital, as I understand it. It's one of their national priorities. And so you're doing work in that area, and you mentioned the carbon abatement with communities there. How does that operate with land tenure, and who would get the rights with those projects, or is that still yet to be determined?
Yeah, so we're looking at how if the community's tenure is secured, and then they keep the mangrove as what it is right now, because they have been saying that we don't want to have this mangrove areas being cleared, cut down because of some highway in construction that is a plan that they heard of. So they have a big vision that these areas will be covered with mangrove for a long time. So if they have secure tenure, and then we try to count that equals to 1,000 hectares, 1,000 vehicles stopped in a year, which very much contributing to the target of NDC of Indonesia. So the government needs to see it this way, and then also take it into consideration which areas can be cut down if it needs to, and which area needs to be conserved for whatever reason, for whatever reason that they are trying to achieve.
Thank you. It was a really interesting case study. There's one more, and we're a bit over time, but there's one more topic I was really keen to hear from you about, and Justine spoke a little bit about sea level rise. So I wonder if Mark and Tillah have any perspectives on how sea level rise and the issue of migrating mangrove habitats is being dealt with. Just smiles, it's a difficult one.
Yeah. We talk about storm surge also, not just sea level rise in the Bay of Bengal. Some people call it Cyclone Alley, and there's just an increase, as we just know from the news right here in the United States where I am. So the mangrove conservation is crucial for these communities. Like in Myanmar, there's something they call the Green Wall, which is 40,000 acres of mangroves that are kind of in the Yangon Delta area. Which is crucial for protecting an entire city. But then you're also talking about communities. It's not just the folks who live in those mangrove areas, but people who live right behind them, that are farming right behind them. So when we think about sea level rise, yes, it gets complex, as Justine showed in her diagram, and we have a similar diagram for Indonesia about if you're slightly above the water, if you're slightly below the water. So it's a tricky land tenure question, and different ministries are involved, as Tillah noted. But we tend to look at it as just another reason to hustle and try to get these laws passed and get them implemented so we can get as many mangrove areas protected as possible, so that there is protection from storm surge.
Right, thank you. And Tillah, did you have?
Yeah. At least we've seen two cases in which sea level rise is actually benefiting the mangrove in Sumatra, in Riau. There's area. It used to be it's an old coconut plantation, like community coconut plantation, but then it is now abandoned because of sea level rise. There was a small kampung or hamlet there that is totally abandoned right now, and they are now doing this initiative to restore the mangrove, and then moratorium of fishing, and then so they after 8 months, then they open the areas and they get big shrimps and everything. So that's one, and the other one is also in the new capital city area. There's also old coconut plantation that is also affected by this sea level rise, but then there's community that changed them into fish ponds, and then we're trying to do some thinking about silver fishery in this area, and they welcome it as long as their tenure is secure, because there is no mechanism yet for fish ponds tenure security. So what if you try this mangrove restoration in your fish ponds, but then your tenure can be secured, and they are very much welcome about it. And one more thing maybe that is found in Indonesia is about the accretion land. There are areas that mangrove can grow very fertile in accretion land, and that is also subject to this tenure communities issues, because there are some accretion land being added because the community keep on planting, but then the accretion land is formally automatically considered as state land, because it seems like it's no one's land, but then actually people are planting.
So accretion land would be like where mangroves are growing out into the sea. Yeah, very, very complex issues to sort through, and I guess need very interdisciplinary teams working on them, because we've just spanned geomorphology to law. So thanks so much, Tillah. I'd like to thank all the presenters who are just out of time now. Did anyone have any final comments they wanted to make, or things they wanted to fill in before we finish the webinar? Oh, okay, there's one question in the chat, so if any of you can have a go at typing an answer to that, that would be great. But thanks everyone for joining the Global Mangrove Alliance webinar on land tenure law and mangrove conservation and restoration. And all of our webinars are available on the Global Mangrove Alliance YouTube channel, and they cover many of the topics we've talked about today, including community forestry, local ecological knowledge in mangrove conservation and restoration, as well as blue carbon accounting. So check those out, and I hope to see you all at the next webinar.